read into the record recited, the parties recognize and agree that it is not presently practicable or desirable to quantify the allocation of contributed income as between the amounts to be applied towards expenses and the amounts to be applied towards the creation of marital property. However, it is understood and agreed between the parties that they will periodically consult with each other as to their expenses and financial plans, and that all decisions shall be made in good faith. I have difficulty understanding that one also. So, this is a hearing as to whether or not there is a binding you can call it a prenuptial or postnuptial, since the document and evidence does not have a date in the introductory paragraph. Although it is signed by the defendant on December 17, 2004, and signed by the plaintiff on May 30, 2003. I don't know if that's a prenup or a postnup, but it's an agreement. And yet it's not dated, and so there's a substantial question as to whether or not one of or both knew what they were signing. Plus, I understand there's also a question where the plaintiff alleges that the last page, which lists a series of parcels of real property, as well as lists a number of different corporations, as well as money in banks or in corporate accounts, whatever that means. It's not, whether or not it is a valid agreement. But yes, well, Mr. Isler, do you wish to be heard on the application?
May I also be heard on what Your Honor just opined?
Yes.
Yeah, I'll be very brief about the application because I personally did not see any conversations between the interpreter and the plaintiff, nor was I privy to how long they were, or how short they were, or where they were. So I'm sure that the interpreter could shed more light on that than I can. But I will say that the only question I asked my client after I heard Ms. Olson's complaint in chambers was, what did you and the interpreter talk about? And she said, I was told by the interpreter that she wasn't feeling well, or hadn't been feeling well. That was it. And I hardly think that that is an untoward conversation influencing the ability of the interpreter to be fair and impartial in translating the questions that are asked or the answers that are given.
Was that the conversation today?
That was the conversation today.
Okay,
yes.
Thank you.
But I did want to say one other thing about the efficacy of the agreement, or whether it is an agreement or not, and that is right in Article 1, in paragraphs A and B. Without reading the totality of the 35 lines or so that are in those two paragraphs, I'd like to point out that paragraph A refers to a Schedule B, which is supposed to be annexed to the agreement, and which is referred to as an acknowledgement and agreement that the bride, prior to the making of this agreement, acquired certain items of property, real and personal, listed and described in Schedule B. I'm paraphrasing only to make sense of those few words. When you get to paragraph B, you see the same line referring to the groom and the same list, or a similar list, listed and described in Schedule A. Well, it's clear from a reading of this agreement, and this is the agreement which is before the court and which bears the signatures and the acknowledgments, etc., that there is no Schedule A and there is no Schedule B. And I fail to see how the court will overcome that omission if those are the schedules which presumably list the items of property, real and personal, acquired by the parties. It's not an insignificant omission. It's not, well, somebody forgot to fill in the date on paragraph 2, but it's all over the rest of the place. It is the heart of this agreement. And if that part is omitted, then the court is called upon to concoct what the parties might have meant or might have included in those lists in order to determine whether this is an efficacious agreement to be interpreted. I think that the omission of those lists is fatally defective as far as the efficacy of this agreement is concerned.
Number one, in plaintiff's pleadings, her causes of action stated that she was unrepresented, coerced, under duress, and that there was no disclosure of assets. What we actually heard in her direct testimony, as a matter of fact, was her inability to understand. A little bit about unrepresented and why, after 6 months of having this agreement, she sought absolutely no one to help her interpret it or to advise her legally. There is much case law in the Second Department about the issue of financial disclosure and prenuptial agreements and postnuptial agreements. Also, that's why we're having this hearing, to talk about the rider. Our position is the rider was attached, and we're going to present testimony that Mr. Isler can cross-examine and explore further. So that's why I assume that we're here, about the validity of this prenuptial agreement, and not just because of the rider attached to it. Also,
It's more than that. It goes to the heart of the agreement because it makes references to Schedule A and Schedule B, which purport to list the property being brought to the marriage but identified as separate property of both the bride-to-be and the groom-to-be. And yet, the document in evidence lacks either Schedule A or Schedule B. And then there is this other page which is not identified as a schedule, but lists a series of properties and corporate entities, as well as a notation about money in banks or in corporate accounts. So there's a question as to whether or not the document clearly exposed the heart of the agreement so that both parties understood what they were signing.
Your Honor, that is correct, and there is people that says even if there wasn't any disclosure, that in and of itself doesn't nullify an agreement. In addition, in other areas of the prenuptial agreement, it says, and she signed, and the plaintiff did sign it, that a rider was attached, that there was full disclosure, and she had a full opportunity to look into the finances. This is a document that she signed. She's not saying she didn't sign it. So within the document, within the paragraphs, within the articles itself, it does say, and she acknowledges, that there was financial disclosure and that the rider was attached.
Well, she also acknowledges that she printed in Mr. Isler's name and address, testifying that she had copied it from a business card which she had received from Mr. Isler's wife, I believe.
And in doing so, Your Honor, she actually lied and she did this because she knew our client wouldn't. So I think these all go to the merit of the application, of what the hearing is about. But as far as the application that we made, when Mr. Isler stated that the only conversation was about Galena's health, I find that incredulous. There were several conversations on 2 separate days, outside the courtroom, inside the courtroom, and I don't believe that if they were really talking about her health, they would have felt the need to go like this and get all upset when the co-counsel looked at her. So I don't find that to be credible to begin with. And it really, given all of these facts and all of the things that were witnessed, it really casts a lot of doubt on this proceeding when apparently there's a lot of questions to begin with. And I think it would be just easier at the beginning points in this litigation to get a new interpreter with the direction that no one is to talk to this interpreter at all outside the proceeding, inside the proceeding, except when she's sitting right in that chair or he's sitting right in that chair.
I said what I want to say about the interpreter, Your Honor.
Thank you. I will deny the application, and we will have Mrs. Polini be called to the stand and the interpreter sitting next to her.
Your Honor,
Please.
I want just to mention, I am a certified court interpreter from Unified Court System of the State of New York, and I interpret Russian. I am not Ukrainian interpreter. There was some conversations at the witness stand because there were questions on the part of the court reporter where the witness gave the name of the school she went to in the Ukraine. So there was, but otherwise I apologize if anything else. But to become a certified court interpreter, I took many exams and tests, and I'm doing it for many years. And this is the first time I heard from someone that the answer was, the question was short and the translation was too long. There's a difference in different languages as far as count of words go, In Russian, we use more words. It's kind of statistics. But these are specifics about my
So
profession.
it's similar to people who live in the middle of Sicily having difficulty understanding people who live in Palermo. They speak differently in Czech. They don't understand them. I understand them. So I will deny the application and will have the plaintiff